Good afternoon. This is Daryl Smith with the Industrial Minerals Association. Thank you for joining us. We'll get started in just a couple minutes, so please stand by. Okay, good afternoon, everybody. This is Daryl Smith. I'm the Executive Vice President with the Industrial Minerals Association, and thank you for joining us on our first webinar of 2013. Today we have Adele Abrams with us, who will be talking about the new pattern of violations rule. Just a couple reminders before we get started. If you have any questions during Adele's presentation, you can type them in at any time. And normally we wait until the end of the presentation and we'll read those to Adele and she'll get your questions answered. And further, at the end of this presentation and by sometime tomorrow, we'll send out a PowerPoint and a in-sync recording of the presentation so that you can watch it at a later date. So you will get a copy of the PowerPoint and the recording of this presentation. So with that, I am going to introduce Adele, who I think everybody probably already knows, but Adele is an attorney and a certified mine safety professional and trained mediator who is president of the law office of Adele Abrams in Beltsville, Maryland, a 10-attorney firm focusing on safety, health, and employment law nationwide. Adele represents employers in litigation in OSHA and MSHA and also provides consultation, safety audits, and training services to companies. Adele is a frequent national speaker and is a columnist for numerous magazines on legal employment, mine, and occupational safety and health issues, and is co-author of several books related to mining, construction, and occupational safety and health. She is also on the adjunct faculty of the Catholic University of America, where she instructs on employment and labor law. Adele is a member of the Maryland, D.C., and Pennsylvania bars, the U.S. District Courts of Maryland and D.C., and U.S. Court of Appeals, D.C. Circuit, 3rd and 4th Circuits, and the United States Supreme Court. She is a graduate of George Washington University's National Law Center and earned her B.S. in journalism from the University of Maryland, College Park. Her professional memberships include the American Society of Safety Engineers, International Society of Mine Safety Professionals, the Industrial Minerals Association, where she's a proud associate member, the National Stone, Sand, and Gravel Association, the American Bar Association, and the Maryland and D.C. State Bar Associations, and the Energy and Mineral Law Foundation. You can always contact Adele at safetylawyer@aol.com. And based on the hundreds of emails I've sent her, she'll get back to you in about 10 minutes usually. So with that, Adele, I will turn it over to you.
Well, thank you, and good afternoon, everybody. I don't know whether I should say I'm pleased to be talking to you about the new MSHA pattern of violations rule, because I know how that theory goes about shooting the messenger, and I'm definitely going to be the bearer of bad tidings when it comes to this particular rule. MSHA's had a lot on its regulatory agenda, and of course, so has OSHA, and a lot of stuff has gotten stalled at Office of Management and Budget or just for political reasons. But this pattern of violations rule has been the centerpiece of MSHA's regulatory agenda through the whole first term of the Obama administration. And so it stands to reason that it would be the first one really that they would bring to fruition here. And one might say, well, we've already had pattern of violations hanging out there, so why should we be concerned about some tweaking to the rule? Be afraid, be very afraid. I'm going to go through why this rule is not your daddy's pattern of violations rule. But to get started here, well, first of all, take a look at, the fact that Congress has been on MSHA to use its pattern of violations powers more heavily. And it is true, there's no getting around it. This was created in the 1977 Mine Act and had really never been used for years, for decades. Then after we started having some high-profile coal fatalities, the Sago mine explosion, then we had Crandall Canyon, and of course, wrapping up with the Upper Big Branch disaster a couple of years ago, there have been a ton of oversight hearings of MSHA wanting to know why they haven't been using pattern of violations. And this was included as part of the statutory criteria in the original 1977 Mine Act, which expanded the Coal Act of '69 to encompass metal and non-metal mines as well. So that's the first basic premise we have to operate on here. Although the coal sector's incidents have been the impetus for Congress putting pressure on MSHA to use pattern of violations more, the fact is that, just like the dolphin in the net with the tuna, the metal and non-metal mines are going to get sucked into this program as well. But let's take a look at the original criteria, which were codified actually back, I guess, in the 1990s in the Code of Federal Regulations. And what that says was that you could get a pattern of violations if you had a history of repeated, significant, and substantial violations of a particular standard. So this is very much akin to, say, an OSHA repeat violation. You're looking at a specific type of hazard as well. So there's two different ways you can go at it. A history of repeated of the same standard, let's say for guarding 56.14107, which is a missing guard. Then you've got the second prong here, which is a history of repeated, significant, substantial violations of standards related to the same hazard. Okay, the hazard is exposed moving pinch points. Under this, if you had some citations that were S&S that dealt with 14107, they could cobble that together with 14112, which is an inadequate guard or an improperly secured guard. So now you've got two different standards but relating to the same hazard, but they could push those together for your history. Same thing could go with mobile equipment safety defects. They could do that under standard 56.14.100, which is your generic defects affecting safety. And then they could add to that a frayed seatbelt, which would be written under the seatbelt standard, or they could do it under the brakes standard for service brakes or parking brakes, or they could add on to this with broken glass on equipment or backup alarms or horns, all dealing with the same type of hazard, which is unsafe mobile equipment. The third prong in the Code of Federal Regulations under the old rule was a history of repeated S&S violations caused by an unwarrantable failure. So those are the 104Ds. And then the fourth prong, and this is again the old rule, was that they would only rely on citations and orders that were final to identify mines with a potential pattern of violations. And this is important because, first of all, the old code talked about having a PPOV, potential pattern of violations, and second, relying only on those that were finally adjudicated. Now, the statute, which is Section 104E of the Mine Act of 1977, this said that if you had a pattern of violations that were of a nature that could significantly and substantially contribute to hazards, so in other words, again, we're just looking at S&S citations, then MSHA has to give written notice about the pattern, and once you get the notice, within 90 days, if they find any S&S violations, then they would issue an order causing you to withdraw everybody from that area, from the area affected by the violation, or if it's an equipment defect, that piece of equipment would have to be taken out of service. And you couldn't go in that area unless you were in charge of fixing the problem, and that's what the ellipse is there. You couldn't go in there until MSHA determined that the violation had been abated. So in other words, it's really in MSHA's control how quickly they come back to verify and terminate the citation or the order based upon your good faith effort to abate it. So the reason I wanted to include the statutory languages in here is to show that this was Congress that said that once you're under pattern, any S&S citation serves as a withdrawal order. That isn't something that was within MSHA's control to change or not change in the new rule that we're going to be talking about here. Now, the rule itself came out in the Federal Register last month, almost a month ago to the day, really, on January 23rd, and the effective date is just going to be a month from now, a month to the day, March 25th, 2013. If there is litigation, which I think is pretty likely at this point, that is no guarantee that a court is going to stay the implementation of this rule. So although sometimes the courts will do that where a showing is made that allowing the rule to go forward would be extremely prejudicial to the litigants, as a general rule with safety standards, they tend not to do that. So you've got to be ready for it. It's coming. And it's coming a month from today. Now, looking at the single source page, MSHA has a lot of information up there, and I've given you the link here. But you know, the final rule appears there. Their policy appears there. There's also a link to a new test balloon that they have, basically, for you to go on there and see what your potential pattern of violation status is under their data retrieval system. And that's been up and running already, but they've tweaked it a little bit with the new criteria, so you can compare under the old and you can compare under the new. MSHA has claimed that only one more mine is going to be added to pattern of violations under the new criteria that we're going to talk about here. I really find that hard to believe, frankly. I have a few clients that are sort of at the cusp of pattern of violations. If you are looking at only finally adjudicated citations, but they are much more in the pocket, so to speak, for pattern of violations if you're looking at simply issued citations, and that's one of the distinctions we're going to be talking about here. So I do recommend, you know, once you get a copy of this PowerPoint, or even before then, go on MSHA's single source page, and there's a wealth of information on there that will help you ascertain where your different mines stand. And that's an important thing to remember as well. This is not company-wide. This is mine ID specific. So, you know, you might have be a company that has 50 mines, and 49 of them are getting, you know, home safety awards, and then you've got one out there that is an outlier because of a particularly bad inspection that they've received, and that could go under pattern violations. So the corporate programs notwithstanding, generally, those are not going to be considered mitigating factors. They're going to be looking at each mine ID under its own history. MSHA has said that there will be net annualized benefits of about $6.7 million under this, and that is after deducting the cost associated with implementation of the rule. They've also claimed that this is going to prevent 1,800 injuries over the next 10 years. I find that a little bit difficult to figure out, but I've always had that problem with MSHA's regulatory impact analyses because there seems to be a little bit of gamesmanship that goes on there. But although MSHA has been selling this rule as one that will force mine operators to immediately correct hazardous conditions and therefore will be greater protection for miners, that ignores one obvious fact, which is that mine operators have to abate issued citations now in a timely manner, or they face closure orders, whether they are under pattern of violation or not. So really, this is doing nothing to expedite the resolution of any cited conditions. You know, MSHA has the same powers now as they had before this rule came out, which is the bully pulpit of issuing the Section 104B order. One of the things MSHA has done in this final rule is eliminated the PPOV stage, the potential pattern violations. And what they have said is that it is up to the mine operator now to benchmark their own status through using MSHA's data retrieval system, which is for free on their website. You put your Mine ID number on, then you go to the home page for your Mine site. There's a bunch of buttons on there that you can hit, including one that says PPOV. So you hit that button, and then it will bring up the various sets of criteria. This is under the old system. The new system will operate much the same way, except that it's going to be up to you to do this. You're not going to get a notice of any sort from MSHA about being at potential pattern of violation stage. The first notice you are going to get from MSHA is actually putting you under a pattern of violations. So what they're expecting you to do as the mine operator, when you see that you are at the cusp of pattern of violations, and we'll talk about this a little bit more as we go through this material, is to go proactively to your district office and figure out what you can do in terms of mitigating circumstances to keep that final tile from dropping and putting you under the pattern of violation status. Now, I mentioned that litigation is likely under this rule, and there's a few different reasons. The first of which is that the actual criteria for what constitutes a pattern of violations is not included in the rule at all. Remember, I went through what the statutory criteria was earlier, and I also went through under 30 CFR Part 104, which is the old criteria that said that you had to have repeated S&S violations of one standard or of a similar hazard, or a history of unwarrantable failures, and only relied on final. But in this case, between the time that they codified the criteria I just read off to you and today, they have put out several iterations of pattern of violations criteria via policy memoranda. And the one thing you need to know about policy from a legal perspective is that it's not binding on the agency and it's not binding on the regulated community. And it does not go through notice and comment rulemaking in the sense that it is required to for a formal rule under the Administrative Procedure Act. MSHA has indicated that if they tweak their policy some more, they'll publish it in the Federal Register and they'll accept comment on it. But because they have said that they do not believe rulemaking is necessary for them to change their POV criteria from time to time, you know, they're under no burden to consider the weight of the administrative record. There's a lot of legitimate legal problems associated with this approach, not the least of which is it's a moving target for compliance for the mine operators. You may think that you're fine today under the pattern of violations criteria that's on MSHA's website today, and they could change that criteria tomorrow and put you smack dab in the middle of a POV status. And that is the real concern, is, you know, the criteria that they have right now, which I am going to outline for you here in a second, is what they're going to continue with for the immediate future. But what happens if, in fact, you know, they've gone through this whole rulemaking, they've switched, as I'm going to talk about, to issued citations, and they still aren't meeting whatever internal quota they might have for putting mines under pattern of violations? It is always a possibility that they're going to have a more expansive criteria the next time so that it will encompass more mines. And that's one of the legal concerns. You know, give us a set of criteria, but then stick with it so everybody, you know, is working off the same page here. The second legal issue is that there's no real due process in appealing your pattern of violation status until such time comes as an enforcement action is taken for a subsequent violation that then serves as a withdrawal order under pattern of violation. So I want to make sure you're following me clearly here, because I realize this can be a little bit confusing. You get a notice from MSHA that says you're under pattern of violations. Now, under the new rule, within the next 90 days, just as it says in the statutory criteria, they're going to come and inspect your mine. But between that notice of pattern of violations and the inspection that maybe is going to occur 3 months from now, there's no mechanism for challenging the pattern finding. The only mechanism that you have is once a withdrawal order is issued for a new S&S citation under pattern of violations, then and only then does it appear you can file for an expedited hearing to have review of the appropriateness of that withdrawal order. And this is a huge deal because they seem to feel that satisfies the due process deficiencies of this rule. I tend to disagree, and let me just give you a little example here. I had a case some of you are familiar with. It was the Knife River Corporation, and it dealt with truck scales, which was one of MSHA's policies that we challenged, and in the end we were successful in challenging. But my client got cited for not having mid-rail guards or railings on their truck scales in October of 2010. We filed for an expedited hearing immediately. The first hearing date that the judge could assign for an expedited hearing was in March of 2011. Then, it's almost like deja vu here, but a sequestration type of thing was happening where they were going to shut the government down. The attorneys for MSHA were told they weren't allowed to travel or do any trials. So the judge was notified. He set it for his next available expedited hearing, which happened to be in May of 2011. So, okay, the citation was issued now in fall of 2010. The expedited hearing is finally held in May of 2011, but it gets better. The judge doesn't rule from the bench. Post-trial briefs are ordered, and then the judge deliberates on it. And in the end, he didn't issue his decision until May of 2012. So basically, a year and a half after the citation was issued, we got the relief of vacating the citation. Well, if you're under a closure order that has been issued as a result of an S&S citation for a mine that is under pattern of violations, can you really say, survive as a business and have all or part of your mine shut down for a year and a half while you get a so-called expedited hearing? And I think this situation is only going to be exacerbated because, as I understand it, with the sequestration that is now supposed to be coming starting March 1st, there's already a ripple effect in the solicitor's office, and all of the backlog attorneys now are being let go. So we're going to be back to a backlog that never has dropped much below that 16,000 case backlog. And all of these expedited hearings under pattern of violations that are possible are just going to be added to that list of cases. So that is a real concern when you're talking about a lack of due process to appeal your POV status before these other enforcement actions occur. There is no mechanism for that in this rule at all. Then the next legal issue is the lack of due process by shifting from finally adjudicated citations and orders to issued citations and orders. This is a very, very big deal because you are effectively serving your sentence before you've had your day in court. And in the audio conference that Joe Main, the head of MSHA, put on when this rule was first announced, I asked that question, well, what happens if the issued citations get changed, vacated, or the elevated actions of the 104Ds, for example, get changed to 104As after you've been put under POV, so that you no longer meet that criteria? And no definitive answer was given because there is no mechanism for having this revisited. He simply said that MSHA would be closely monitoring mines once they are placed under a pattern of violations. But I can't imagine that they're going to be that quick to give relief when it is called for. And if you're hearing a buzz in the background, they appear to be mowing the lawn outside my office window, so I'm sorry about that. So let's take a look at the screening criteria. These are basically the same criteria that were in effect for the pre-screening for potential pattern of violations under the old rule, and these will now be the final screening criteria under the new rule, at least until such time as MSHA puts out new policy. And there's two different ways, two different scenarios that you can come under pattern of violations. The first is a four-prong approach. All four of these tiles have to fall, so to speak. The first one is you have to have at least 50 citations or orders for S&S violations issued in the most recent 12 months. So it used to be a 24-month window under what's in the old Code of Federal Regulations. Now we're shifting to a 12-month window, but they're pretty ambiguous about how that is going to be measured. Each mine is going to be screened for pattern criteria at least once a year, but they don't make it clear whether they're looking at this on a calendar year basis, whether they're looking at this on an MSHA fiscal year basis, or whether it's going to be a rolling 12-month window, similar to what we have now, just to further confuse things, the 15-month rolling window for history of violations and repeat violations under the penalty point system that's in 30 CFR 100.3. So in one hand, we got a rolling 15-month window, but this is a 12-month period, and it says the most recent 12 months. So how MSHA is going to ultimately apply this is going to be anybody's guess. But so at least 50 during 12 months. Can you get 50 citations in a single inspection? You bet. All you need is to be one of the unfortunate souls that is subject to an inspector audit inspection, for example, when they've got a team auditing how well he's writing citations, or you get put on one of these impact inspections where you are tag teamed by a group of inspectors and they come in, or you just have one inspector who's ticked off at you for some reason. This, again, it doesn't mean that any of these citations have to be valid. It simply means that they have to be issued. I have lots of aggregate operations. I have industrial sand operations that, and other metal, non-metal sector clients who do get 50 or more citations in a single inspection, much less in a 12-month period. So I think that criteria is going to be met by a lot of mines. The second is that you have to have a rate of 8 or more S&S citations issued per 100 inspection hours during the most recent 12 months, or the degree of negligence for at least 25% of your S&S citations is either high or reckless disregard. Well, let's take a look at this criteria a little bit. First of all, I'll drop to the second point of the high negligence. There are inspectors out there, especially the baby inspectors, and 40% of MSHA inspectors have been with the agency for fewer than 2 years because you've had so many retirements. They are being told at the Mine Academy, write everything as high negligence unless the mine operator talks you out of it, and then don't let the mine operator talk you out of it. So I see cases all the time where every single citation is written as high negligence, and it doesn't matter if it's on a truck that was parked, and when the inspector checks it out, the backup alarm doesn't work. They check that high negligence box. So it doesn't mean that you have to have engaged in egregious conduct. It simply means the inspector arbitrarily decided he was going to check the high negligence box. This doesn't mean they have to be 104Ds. This can be Section 104A, S&S citations checked off as high negligence. And as I said, these are pretty much, almost the norm now rather than the exception, which certainly is not how it was 10 years ago, for example. Now, let's look at that rate of 8 or more S&S citations, regardless of the negligence characterization, by the way, per 100 inspection hours. Well, first of all, metal, non-metal mines get a lot fewer inspection hours than coal mines. There's just no getting around that. The second thing is that it's my understanding under the sequestration, which, wasn't something considered when MSHA put this rule together, obviously. They are talking about that they will still make all of their coal inspections, but they may not do all of their metal, non-metal inspections. My prediction, and this is only a prediction, is that if they're not going to be visiting your surface mines twice a year and your underground mines 4 times a year, but maybe they're going to do 1s and 2s instead of 2s and 4s, they're going to try to get a bang for their buck. And when they're there, they're going to be writing some heavy paper and lots of it so that the overall number of citations issued doesn't drop appreciably. Well, if that happens, you're going to have fewer inspection hours to offset the citations that you receive. And, I do have quite a few mines already that when you're looking at it per 100 inspection hours are at a rate of 8 or more. It is just not that difficult to get there. So keep in mind that's the second tile. Then the third one is that you have at least 0.5, that's 0.5 elevated orders and citations during that are issued per 100 inspection hours. Okay, you've heard my comments on the inspection hours. Same thing goes here. Some of these inspectors are just handing out 104Ds. They're handing out imminent danger orders under 107A. Now that task training is one of the rules to live by, I'm seeing a lot of 104G orders being issued there, and also 104Bs, which are failure to abate. Those are what they consider to be the elevated actions. And believe me, it is not that difficult to get to 0.5 elevated citations and orders issued per 100 inspection hours. It's a lot harder for them to get to that if they are only relying on finally adjudicated ones, because we get a lot of these elevated actions changed in settlements, in conferences, or if we have to go to trial. So again, remember, it's not just Ds that we're dealing with here. And then the last criteria under set 1 of the screening criteria is a 12-month injury severity measure for the mine that is greater than the overall severity measure for all mines in the same mine type and classification over the most recent 5 years. And this is, basically your lost work day and your non-fatal days lost, and on total injury rates, actually, is what they're dealing with here. Well, what they consider to be the same mine type and classification can be a little bit arbitrary. For example, if you're an industrial sand operation, are you going to be lumped in with all sand and gravel operations? Are you going to be lumped in with stone, sand, and gravel? Or are you going to be all metal, non-metal? Not entirely clear how MSHA is going to play with this. If you're coal, you're coal. If you're metal, you're metal. But with the non-metal, it does get a little bit fuzzy here. So if you are a mine that has not had a lost time accident in the last 25 years and you aren't going to have any coming up, you're not going to get under pattern of violations. But if you've had a couple of back strains and you don't have the number of man hours at this particular mine ID to offset a couple of injuries, you may find that your injury severity measure is higher than comparable industry, especially if there are a lot of large mines in there and you happen to be one of the smaller operations. So again, there's a bit of arbitrariness to this. Okay, then we get to the set 2 of the criteria. And remember, this is either or. You can be placed under pattern violation if you meet the criteria in set 1 that we just talked about, or you meet this. Set 2, at least 100 S&S citations in the most recent 12 months issued. Again, can you get there? Certainly you can, because I have some fairly small family-owned companies that are up in this league. And then the second prong of that is you'd have to have at least 40 elevated citations and orders issued during the most recent 12 months. That one is a little bit harder, but I've had an aggregate operation that MSHA came in and wrote 20 104Ds in a single inspection. Very few of them ended up standing at the end of the day when we settled the case. But again, we're just going on issued criteria at this point. And it's not just Ds. So you could get Bs. One of the games that I have seen MSHA play is in the amount of time they give you to abate something. Let's say they issue 10 guarding citations and they give you 3 hours each to abate them. They will come back 3.5 hours later, and if you haven't already fixed the guards, you will get a 104B order. So this is, again, cumulative. It would be a total of the Ds, the Bs, the Gs, and the 107As. And if in toto, in the past 12 months, you've had 40 of these issued, then you would meet that criteria. So although MSHA, was trying to be, I think, calming when they had their press conference on this and say very few mines were going to come under POV, I can see lots of scenarios how mines can be brought under this, even if they are, generally good mines with decent safety programs and good safety performance. In fact, just a little aside, I had my first encounter with this back when one of my clients got a PPOV letter, and this happened to be an industrial sand operation, And we went up and had the meeting at the district manager's office. And when he found out that they had written this letter based upon issued citations incorrectly, it should have been on finally adjudicated, he immediately dropped the PPOV. And at the same time gave them a letter from the Home Safety Association recognizing their outstanding safety performance. So, you know, the right hand doesn't know what the left hand's doing on this stuff, I guess is the best way to put it. Now, there's some new POV procedures under this rule. First of all, every mine's POV status is going to be reviewed annually, and you, in turn, are expected to monitor your PPOV status by using the tools on MSHA's data retrieval system. Now, if you see that you are on the cusp of pattern of violations, then you are expected to proactively go to the district manager. You can prepare what they're calling a corrective action plan and submit that for approval by the district manager. And this is a key thing because if the district manager doesn't approve your corrective action plan, it will apparently not be considered a mitigating factor. Once they approve it, it still has to be effective in reducing your significant substantial citation rates in order to be considered a mitigating factor. And the problem with this is that in your mind and your view, the plan may have been successful in eliminating hazards, but that doesn't mean that you're not going to get an inspector in there who's going to issue you a whole raft of citations anyway for conditions that previous inspectors had accepted. They are doing this, you know, even though there's a drive toward consistency and guarding by putting out all the new materials they have. I have a case right now where they came to an operation, and this is, again, a relatively small family-owned company, and they wrote 8 guarding citations, wrote them all as 104Ds, and have proposed $537,000 in penalties. And this was during a routine inspection. This was not anything associated with an accident. It's all up to the inspector how they categorize things, and we've seen this variability, and I'm sure you've seen it too, where you might get a citation for a parking brake from one inspector and it's non-S&S, and then the next inspector cites you for a parking brake on the same equipment operated under the same circumstances, and he writes it up as reasonably likely to be fatal. So there's so much discretion left to the inspector that, you know, you may have the most effective corrective action plan in the world, and you just happen to have the luck of the draw and get an inspector who likes to write everything as S&S, and it's not going to be considered a mitigating factor. The rule is also pretty vague about what has to be considered in included in a corrective action plan. And of course, you may have safety professionals developing this corrective action plan for you, but there's no guarantee that you're going to have a district manager who will appreciate the work that has gone into it or will agree that it passes muster in his view. So those are a few of the variables as well. Now, under the old rule, they talked about safety and health management programs and corrective action plans. They've dropped the reference to safety and health management programs because a lot of people got confused because MSHA had a safety and health management program rulemaking on its agenda separate from the pattern of violations, and they wanted to make it clear that they weren't trying to backdoor that standard here. So we're back to calling it corrective action plan. And MSHA did give a bit of a hint in the proposed rule about what might meet the district manager's criteria. So these are a few of the things on the slide we're looking at now. The first is the corrective actions you plan to take, setting benchmarks and milestones, you can call them matrices if you wish, to reduce the frequency of S&S violations. The second is specific changes that the operator is going to make to improve the quality or increase the frequency of examinations conducted by your qualified and competent personnel. Now, under the metal non-metal standards, you're already required to do a workplace examination in every active work area at least once each shift. You know, I looked at this criteria and I'm thinking, how in the heck are you going to increase the frequency beyond that? You're already, you know, if you're running 3 shifts, you're doing 3 of these inspections in every work area a day. But this is one of the criteria that you're going to have to demonstrate to a district manager. also remember, as you are putting together one of these, that every individual who does a workplace examination is considered to be an agent of management under that Nelson Quarries case from 2009, which was a commission decision, so it's binding precedent. And that stood for the proposition that hourly employees who perform workplace examinations are considered agents of management because they are authorized to promptly initiate corrective action. So if you're going to increase the frequency of these examinations, if you're expanding the scope of individuals who are going to perform these evaluations and inspections, you need to make sure they understand that they can be personally fined up to $70,000 under Section 110C of the Mine Act if they are inspecting an area, or they fail to identify and correct a hazard, or if indeed they are caught doing anything else. They're not wearing a seatbelt, but they're identified as being a workplace examiner. Their negligence is imputed then not only to the company for purposes of a 104D, but also it bounces back on them personally. The next thing in the corrective action plan is you would have to identify specific actions that mine management would take to pay greater attention in reviewing examination books and records, and also discussing the examination results with examiners. Now, the language in this really, I think, relates more to the coal standards, which have, the mine examiners, but I could certainly see them also imputing this to the workplace examinations that you have to do under the metal, non-metal standards, both for the workplace conditions and also perhaps the examinations that are done pre-shift on mobile equipment. This is a question that I get frequently anyway in these cases. It's like, well, great, these records are done, but who reviews them? And very often they just get put in a bin in someone's office and maybe are reviewed on a weekly basis. So that's probably something that you'd need to delineate with greater specificity in putting together a corrective action plan. And this also raises the issue about the workplace examinations, because technically, under the current standard for workplace exams, which is 56 or 57-18-002, you simply need to make a record stating that, on February 25th, 2013, Iadel Abrams, on the day shift, inspected the high wall area. You don't have to list on there what the conditions were that you found, whether they were satisfactory or not, nor do you have to list what corrective actions were taken. And MSHA tried via policy to force operators to do that a couple of years ago, and they got smacked back on it. So at this point, this might be one of the things that a district manager would demand as part of a corrective action plan, is to actually list on there what the conditions were that were observed and what remedial action was taken. Remember that those workplace examination records under 56-18-002 have to be retained for a rolling 12-month window, and MSHA can issue citations based upon the hazards that are listed on those records, even if they have been corrected, because of there being strict liability and no statute of limitations. So if that is one of the elements of a corrective action plan, there could be additional legal consequences flowing from that. Another thing is that you're going to have to announce the frequency in which you're going to conduct unannounced examinations of the mine and audit mine examinations and compliance. Well, so now, to be an acceptable corrective action plan, you're likely going to have to do formalized audits. And what I read into this is that MSHA is going to have the right to verify your compliance with the corrective action plan, which means that those audits would have to be produced to MSHA because that would be part of a plan that you have bound yourself to. And again, as with the workplace examination records, anything that is identified as a violation in an audit record is something that MSHA can cite you under, because they don't have to see a violation in order to cite it. They simply have to believe that a violation has occurred. So, on one hand, you're escaping a POV finding, but you may be self-incriminating in other ways. And then the other criteria here was having to add safety and health staff to assist in the daily auditing of compliance performance, and how you're going to do that and give them the authority to halt work if violations are identified. So, right now we're in still some tough economic times. People are trying to do more with fewer personnel, but if you come under a corrective action plan, in all likelihood, the district manager is going to require you to beef up your safety department, which I suppose is good news for all of us safety and health professionals out there, bad news for the bean counters. But there's more, and this again all came out of the explanation about corrective action plans that's been in the material MSHA's had out on its website as well as in the proposed rule. They're going to want you to include specific additional training on minors' rights so that the minors will know how to report hazards internally as well as to MSHA, and also be aware of their rights in protecting them against retaliation for being a whistleblower. You're going to have to indicate what training you're going to give mine officials, mine examiners, your competent persons, all of whom are considered agents of management, and also to minors to address the various conditions that caused your quote-unquote unacceptable level of citations and orders that have been issued during the screening period. So you're going to have to review your history, all S&S citations, and elevated actions that contributed to your PPOV status, and go through those with all of your personnel to address the conditions and how you're going to avoid that in the future. In addition, they're going to be expecting modifications or additions to engineering or administrative controls that address specific conditions or practices. This may not apply in every situation, but for example, if you've been getting a pattern of high wall citations on ground control and stability, they'd probably like some engineering controls to address that. If you've gotten elevated actions because of silica exposure, they're going to want engineering or administrative controls to address that. So it's not a one-size-fits-all. They're going to be looking at the unique characteristics of your mine, what conditions and practices form the basis for your PPOV status. You're also going to have to identify the personnel who are responsible for implementing and monitoring the corrective action program, or as I like to call them, your designated felons, because presumably if they are responsible and you're identifying them as responsible for doing this and they fail to do it, there could be some consequences for them. You're going to have to set milestones and benchmarks to implement each phase of this program, and you're going to have to give some dates by which it's going to be achieved. And then finally, you're going to have to tell them how you're going to ensure the milestones are achieved and how you're going to notify the district manager on the program's progress. So there's a lot that goes into this. When MSHA was calling it a safety and health management program, their estimate was that it was going to cost about $22,000 per mine ID, to develop one of these. Now that they're simply calling it a corrective action plan, they've cut the final cost analysis or estimate of this to $11,000. But I think they're still being pretty optimistic, especially in terms of the cost of implementing these programs and not just developing the programs. So let's take a look at what are the consequences if you come under pattern of violations under this new rule. Well, it really relates back to the 1977 statutory criteria. Once you're under POV, you're going to get a written notice, and then MSHA is going to come in and they're going to do a wall-to-wall inspection within the first 90 days. And then for each inspection cycle thereafter, which is, in a sense, not a whole lot new, unless you're a surface mine and you only get inspected twice a year. In that case, they might be showing up earlier than they would otherwise. And then once you're under POV, every S&S citation you receive that is issued is going to mean a withdrawal order. And those do not have to be elevated actions. They don't have to involve high negligence. They don't have to involve imminent danger orders to trigger a withdrawal order. They see a piece of rock on a high wall that they think is unstable, even though you haven't seen any movement on that wall in the last 10 years, that whole high wall area will have to have miners withdrawn from it. It'll have to be barricaded off until you have remediated it to MSHA satisfaction, and they come back to verify and terminate the citation. If you have built-up material on a conveyor walkway, that whole conveyor system may be shut down. Obviously, if an S&S citation involves a singular piece of mobile equipment, that piece of equipment would be taken out of service. And usually mines have enough equipment that they can kind of cover with other. But you can see that this could have ramifications that are pretty widespread. Now, beyond that, termination of the pattern of violations notice only occurs when they've had an inspection of the entire mine and had no S&S violations, or if you've had no withdrawal orders issued in accordance with this within 90 days. But all it takes to keep you under pattern of violations for life is a single S&S citation once an inspection. So basically, to put it pretty bluntly, any inspector can keep you under pattern of violations forever simply by issuing an S&S citation. And in fact, as a practical matter these days, it is very rare that you have an inspection without at least one S&S citation. Plain vanilla 104A, it might be reasonably likely to result in lost work days or restricted duty. That still is an S&S. Doesn't matter if it's low negligence, that still is going to be enough to keep you under pattern of violations until your next inspection, whenever that may occur. If you resume a practice that gave rise to the issuance of pattern of violations after being taken off pattern of violations, you'll go back under pattern of violations. And they're going to be looking at the original circumstances and also your most recent conduct. So there's, again, two ways they can go at that. So if you were placed under pattern of violations because you had repeated guarding violations and now you get a new guarding violation, even if it's non-S&S, arguably they might look at that as being a resumption of the practices that gave rise to pattern of violations. A lot of this is not clear. It's certainly not because I haven't read the rule. It's because the rule is written in a very vague manner, and we're going to have to see how this plays out with MSHA guidance that may be issued on this in the days and months to come. Trying to move this along here. Okay. Before we wrap up here, I did want to mention that there's more ways that they can find you under a pattern than going through the strict pattern of violations criteria that's in this final rule. And this is important to mention because this can encompass a lot more mines potentially. There was a case in 2010 called Solis versus Freedom Energy Mining Company, and this is where MSHA went to the U.S. District Court for the district where the mine was located and sought an injunction to close the mine down because the mine had a, quote, pattern of violations, unquote, that constituted a hazard to the health or safety of miners, but they didn't meet the formal pattern of violation criteria that I have just gone through. And the court said, you know what, that's okay. You don't have to meet the formal POV criteria for us to issue an injunction and shut the mine down. And in this case, MSHA was trying to get them to implement a safety and health management program for approval by MSHA before it could resume production. That was what they wanted to do as part of this whole injunctive practice. And basically what happened in the case was the mine just threw up its hands and said, okay, we're done here, and they closed it. So, how this would have played out if the mine had stayed open will always be a bit of a guess. But the important thing is that MSHA found, that MSHA was found to have the power to get an injunction because of repeated violations that pose significant hazards to miners, even where they didn't formally meet the POV criteria. And I think we can expect to see MSHA using this power a bit more. This was their first use of the injunctive powers under Section 108A1, A2 of the Mine Act, and that says that whenever the Secretary believes that the operator of a coal or other mine is engaged in a pattern of violations which constitutes a continuing hazard to health or safety of miners, they can institute this action for a temporary or a permanent injunction, restraining order, or other relief. And the court explained this as saying that whenever the Secretary believes that a mine operator is engaged in a, quote, pattern of violations, they can come to court and get relief. You don't have to meet that formal criteria. This, by the way, the Section 108A is also the provision that allows MSHA to go and get injunctions for other things. And I've spelled these out here. If you refuse to comply with any order, they can get an injunction. If you interfere with their inspections, they can go and get an injunction. If you refuse to let them into the mine, they can get an injunction. If you refuse to allow inspection, or an accident investigation, they can get an injunction. And the one that I'm seeing used more frequently now, although they haven't really been going to court on this, they're just threatening it a lot, is under 108A1E, which is where you refuse to furnish, quote, any information or report requested by the Secretary in furtherance of the provisions of this Act. Well, under that already, they are using this to try to compel production of safety audits, near-miss accident investigation report, other privilege documents, workers' comp records, records from your insurance companies, Safety and Health Committee meeting minutes, you name it. These are all non-mandatory documents. These are things that are not required to be maintained under the Mine Act, nor any of the implementing regulations, and yet they threaten to go to court and get an injunction if you refuse to produce these documents. So they are feeling their oats when it comes to injunctive powers, and so this is just another way for them to attack mines that maybe don't meet the formal pattern criteria, but they still want to shut down for one reason or another. So the bottom line is that pattern of violations is here. It's MSHA's new toy. I think it's safe to say they're going to want to take it out and play with it a little bit, and consequently, I believe it's going to lead to the issuance of more elevated actions and probably a presumptive S&S classification for pretty much every citation other than paperwork violations. But if you proactively implement a corrective action plan, this can lay the groundwork for demonstrating mitigating circumstances to avoid a POV action or injunctions. And if it's properly implemented and it's a good program, it should lead to fewer citations overall and improve your incidence rate. But there is that issue that ultimately your number of citations that are issued are going to be within the discretion of the inspector or inspectors if they play tag team on you. And so a corrective action plan really is not going to insulate you from having a bad inspection necessarily. But the bottom line is that you do need to monitor your IDs on that data retrieval system website. Go ahead, the tools are up there now. You can check it out under the old POV, which relied on finally adjudicated citations. Then you can use MSHA's new system, which is on that single source page link that I gave you earlier, and see how you frame up under the new issued criteria. And that should give you a sense on whether or not you need to start developing a corrective action plan. But it is on your shoulders. The first thing you're going to hear from MSHA is a letter putting you under POV. So you want to take proactive steps to avoid being publicly identified as being one of the bad actors, being one of the worst of the worst. So I'll stop at that point, and I'm happy to answer any questions that might be out there. And I thank you for your attention.
Okay, thanks, Adele. We do have one question so far, and if you have any other questions, please go ahead and type them in. The question that we do have is, what would be the definition for area as to how MSHA would apply a withdrawal order on a mine site?
Well, that is a great question, and it's one of those issues that MSHA has not clarified in the rule. I will tell you this, though. They tend to take a very expansive view. For example, when I've had cases with high wall issues, they don't just danger off, 15 feet out from the high wall. They will tend to try to close down the haul road that runs in proximity and say, well, a rock could fall, it could bounce up and fly out farther. And in some instances, I think they do this intentionally with this expansive view of area affected in order to compel the mine operator to more readily take termination actions that MSHA wants. if you're only having to danger off something by putting up some Jersey wall and keeping people from traveling too close to a high wall, but you can still use your roads, you're more likely to try to get an expedited hearing and challenge that. Whereas if your whole road is shut down and you literally can't haul any product, they're more likely to be able to force you to go in and make engineering controls that you might otherwise try to avoid. Similarly, they're big on structural deficiencies these days. And I had a client that got cited for a silo that MSHA thought had some bulging areas. And they blocked off circumference, the height of that silo, in all directions, which managed to encompass both of the roads at the mine. They put that under an imminent danger order, so it's very similar to what we're talking about here in terms of a closure order under POV. And in that situation, they would not allow them to use either of those roads until they knocked down this silo, which at a cost of hundreds of thousands of dollars to them. But they issued a B order, which is an elevated action to hold them. So now you had a 107A and a 104B. That's two elevated actions toward POV status right there. But the point is, on the area of the mine, it's going to be within the control of the inspector to delineate what the area is that's affected. And just in my experience with these, as well as some other situations that come to mind, they are going to err on the side of caution. So you can expect a massive shutdown.
Okay, we did get one more question, and it's, I have read that there will be cutbacks in the number of MSHA inspectors due to the government cutbacks that are expected. And realistically, what percentage of mines could be put on POV given the MSHA resources?
Well, it's as I said, because this is done in terms of rates and not necessarily dispositive on the number of citations, it actually may work in MSHA's favor if they cut back the number of inspection hours at a mine, but don't cut back on the number of citations being issued during a visit. In other words, if they try to double up the number of citations because they know they're only going to be there once a year. So that could actually have an effect of increasing the number of mines that meet POV criteria. As a practical matter, with the sequestration, MSHA's looking at losing about $31 million, which is not a huge percentage of their budget. And there's a lot of discretionary spending within MSHA. I mean, even though I think the president has been trying to paint some of the worst case scenarios, whether it's talking about air traffic controllers or talking about MSHA inspections, when the rubber meets the road, they could cut back on the small mines office, they could cut back on state grants, they could cut back on some of the training programs at the mine academy, they could cut back on some of the administrative personnel that they have, clerical personnel. There are a lot of cuts they could make before it comes to cutting back on inspectors. And given the fact that they have a statutory mandate, unlike OSHA, to conduct specific numbers of inspections at mines each year, I think the inspector hours are going to be the last thing to go. That's just my opinion, though.
Okay, Adele, that's all we have, and thank you very much. That was very informative. I'll just let everyone know we do have a couple more webinars that aren't scheduled yet, but that are in the works. One involves the SEC reporting requirements, the new SEC reporting requirements on public mining companies. And we're also working on a webinar to help people deal with kind of their local congressional offices, inviting people to do site tours, that kind of thing. So you'll see announcements on those coming up shortly. And if anybody ever has a suggestion for a webinar, let us know. Send it to either myself or Chris Greising, and we'll get that scheduled. So thank you, everyone, for attending, and thank you again, Adele, for putting that together. And again, Adele's contact information is safetylawyer@aol.com. And everybody have a nice day. Thank you.
Thanks.